Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from the Prime Minister, the Honorable Dr. Keith Rowley, MP, Member for Diego Martin West, the Honorable Camille Robinson Regis, MP, Member for Aruka Maloney, the Honorable Stuart Young, MP, Member for Port of Spain North, St. Anne's West, and Dr. Lakram Bodo, MP, Member for Faisabad, who have requested leave of absence from today's sitting of the House. The leave which the members seek is granted. Honorable members, correspondence has been received from the President of the Senate dated November 1st, 2019, which states as follows. Dear Speaker, re-establishment of Joint Select Committees. Reference is made to your letter dated October 22nd, 2019 on the subject at caption. I wish to advise that at a sitting held on Friday, October 25th, 2019, the Senate concurred with the House of Representatives in the establishment of the following committees, and that the respective committees be mandated to adopt the work of the Joint Select Committees appointed in the 4th session, 11th Parliament, and report by December 31st, 2019, and that the following senators be appointed to serve. The Joint Select Committee to consider and report on the miscellaneous provisions, Local Government Reform Bill 2019. Mr. Clarence Rambachan, Mr. Kazim Hussain, Mr. Daniel Duki, Ms. Khadija Amin, Mr. Paul Richards, Mr. Diorop Timal. The Joint Select Committee to consider and report on the Private Security Industry Bill 2019. Mr. Clarence Rambachan, Mr. Nigel De Freitas, Mr. Foster Cummings, Mr. Saddam Hussein, Mr. Paul Richards, Dr. Varma Diyal Singh. The Joint Select Committee to consider and report on the Cybercrime Bill 2017. Mr. Clarence Rambachan, Mrs. Paula Gopi-Skoon, Ms. Donna Cox, Mr. Wade Mark, Mr. Paul Richards, Mr. Anthony Vera. The Joint Select Committee to consider and report on the Gambling, Gaming and Betting Control Bill 2016. Ms. Alison West, Mr. Robert Lee Hunt, Mr. Foster Cummings, Mr. Wade Mark, Mr. Paul Richards, Dr. Varma Diyal Singh. The Joint Select Committee to consider and report on the Mutual Administrative Assistance in Tax Matters Bill 2018, the Tax Information Exchange Agreements Bill 2018, and the Income Tax Amendment Bill 2019. Mr. Clarence Rambachan, Mr. Daniel Duki, Dr. Lester Henry, Mr. Saddam Hussein, Mr. Paul Richards, Ms. Charis Sipasad. The Joint Select Committee to consider and report on the Constitution Amendment, Tobago Self-Government Bill 2018. Mr. Clarence Rambachan, Mr. Nigel De Freitas, Mr. Foster Cummings, Mr. Saddam Hussein, Dr. Varma Dial Singh, Dr. Maria Dillon Remy. The Joint Select Committee to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018. Mr. Clarence Rambachan, Mrs. Paula Kopi-Skoon, Dr. Lester Henry, Mr. Tahaka Obika, Ms. Amarita Dionorine, and Ms. Charis Sipasad. On the said date, the Senate also agreed to the following resolution. Be it resolved that this Senate agreed to the following appointments to the Joint Select Committees. On the Public Administration and Appropriations Committee and the Joint Select Committee on State Enterprises, Mr. Foster Cummings in lieu of Mr. Gavin Simonet. And on the Joint Select Committee on Human Rights, Equality and Diversity, Mr. Sean Sobers in lieu of Mr. Ashvani Mahabir. Accordingly, I respectfully request that the House of Representatives be informed of these decisions at the earliest convenience, please. Respectfully, Senator the Honorable Christine Kangaloo, President of the Senate. Honorable members, correspondence has also been received from the President of the Senate dated November 14, 2019, which states as follows. Dear Speaker, reappointment to Joint Select Committee. I wish to advise that at a sitting held on Tuesday, November 12, 2019, the Senate agreed to the following resolution. Be it resolved that this Senate agree to the appointment of Mr. Foster Cummings to the Public Accounts Enterprises Committee. Accordingly, I respectfully request that the House of Representatives be informed of this decision at the earliest convenience, please. Respectfully, Senator the Honorable Christine Kangaloo, President of the Senate. Honorable members, I just wish to draw to your attention that today we have in the gallery 42 students and 4 teachers from the Goodwill Methodist Primary School to observe our day's sit-ins, and on your behalf, we welcome them.
Bills brought from the Senate, petitions, papers.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I have the honor to lead the following papers. The ministerial response of the Ministry of Finance to the 16th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Trinidad and Tobago National Petroleum Marketing Company Limited for the years ended March 31st, 2008 to 2017. Also, the ministerial response to the Ministry of Energy and Energy Industries to the 16th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Trinidad and Tobago National Petroleum Marketing Company Limited for the years ended March 31st, 2008 to 2017. Thank you very much.
Reports from committees, Prime Minister's questions.
Honorable members, having regard to the fact that the Prime Minister has been granted leave of absence for today's sitting, Prime Minister's questions have been deferred to the next sitting day.
Urgent questions.
Member for Shogunas East.
Thank you, Madam Chair. On behalf of the member for Shogunas East to the Minister of Education, could the Minister confirm how many cases of the H1N1 influenza virus have been discovered at Shogunas North Secondary School, and what measures have been put in place to prevent its outbreak at the Shogunas South Secondary School?
The Minister of Education.
Madam Speaker, with the agreement of my colleague, the Minister of Education, I will be taking this question. I would like to inform the population that there was one suspected case. It was a school teacher. The school teacher has since fully recovered because the common cold, as we know, is self-limited. There has been no confirmation of any outbreak of H1N1 at the Chaguanas North Secondary School. Since the report of that teacher being ill with what seems to be the common cold, the school has in fact been sanitized, and the best measures anybody can take is cover your hands, cover your nose and mouth when you are sneezing, wash your hands frequently, use antibacterial agents and so on. In this case, prevention is a whole lot better than cure. May I also add that the government has brought in over 100,000 doses of influenza vaccine, which are available at all health centers and have been so. May I also tell the national population that so far, the uptake of these vaccines has been disappointingly low. So I urge the 5 categories of people that we like to vaccinate, that is pregnant women, school children between 6 months to 5 years, those who are immunocompromised, the elderly, especially those with diabetes, and healthcare workers, to please, the uptake has been disappointingly low. Make yourselves available for the free vaccines. Thank you very much, Madam Speaker.
Member for Couva South.
Thank you, Madam Speaker. To the Minister of Energy and Energy Affairs, could the Minister inform this House whether the government has taken a decision to intervene in the gas sales negotiation contract between the National Gas Company and Yara Trinidad Limited in order to preserve the operations of the company and the jobs of the employees at Yara?
The Minister of Energy and Energy Industries.
Thank you very much, Madam Speaker. And just for the records, I want to inform the member for Couva South that I'm the Minister of Energy and Energy Industries. Just for the records. Madam Speaker, as is well known, the government does not get involved in commercial discussions between parties. It therefore does not intend to intervene in the matter between Yara and the NGC. Indeed, the Yara management has already taken a decision to cease operations and to mothball the Yara ammonia plant. They have advised that the operation of the plant is not viable based on its current cost structure, the market conditions for ammonia, the new gas prices, and probably most importantly, and let me repeat this, most importantly, plant inefficiency, and also the fact that this plant is the most inefficient plant on the entire estate. It is 50 years old, and the last upgrade was done 20 years ago. The real issue, Madam Speaker, is that the challenge facing the gas sector, which we have brought sanity to, and we have partially and leading to full resolution, is that the UNC went to sleep between 2011 and 2015. They failed to renegotiate upstream gas purchasing contracts, all of which were expiring between 2016, 2017, and 2018. These contracts had to be renegotiated years in advance. They also failed to negotiate new gas sales agreement with downstream operations at Point Lisas. That led to $4.0 billion in claims towards the NGC. We have virtually sorted all that out. And probably the most significant aspect is the issue of...
Time is now expired.
Okay, good.
Supplemental, member for Couva South.
Thank you, Madam Speaker. Minister, based on your flippant approach here that the government will not intervene, could you tell us how many workers will lose their job directly and indirectly to add to the 63,633 persons who have already lost their jobs in this country?
Madam Speaker, there are 60 workers that are currently employed at the Yara plant. It is the intention of Yara, which is the operator of the Tringens 1 and 2 plant, which is owned 49% by Yara and 51% by NEL, to absorb as many of those 60 workers as is possible. So the full liability would not be 60.
Supplemental, Caroni Central.
Based on your initial response, your first answer, are you saying that given what your assessment is of the plant, how old it is, how inefficient it is, are you saying that it's okay if it closes its operations?
Minister of Energy and Energy Industry.
Decision for the owners of the plant. I'm just outlining what are the factual basis in which the decision was made. I cannot close the Yara plant. It's only the owners of Yara can sue me.
Member for Couva South.
Thank you, Madam Speaker. To the Minister of Education, could the Minister inform this House when will classes at the Couva West Secondary School for the 770 students and 59 members of the teaching staff resume, taking into consideration that the school has been closed since the 16th of October 2019?
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, work at the Couva West Secondary School is currently 70% complete. The contractors sanitized the facility and asked Kariri to conduct an air quality test. Kariri is expected to provide the results to the Ministry of Education by November the 15th, 2019, which is today. The outstanding works are being carried out and are expected to be completed by November the 19th, 2019, and that is Monday. In these circumstances, Madam Speaker, the Couva West Secondary School is expected to resume classes on November the 20th, 2019. Thank you.
Supplemental, Member for Couva South.
Thank you, Madam Speaker. Minister, could you tell this House what has been put in place for classes as it relates to students who are due to write the CSEC examinations in 2020?
Minister of Education.
Thank you very much, Madam Speaker. I have been informed by our Director of School Supervision that she has been in contact with the line supervisor, who in turn has been in contact with the principal, who has given us the assurance that the teachers, in their usual style, will do everything to make up for lost time. And it is hoped that this is carried out so that our students will not be disadvantaged. Thank you.
Supplemental, Member for Couva South.
Madam Speaker, today I will tell the Minister of Education that he is delinquent and misleading this House. There is no remedial classes. Madam Speaker, I was elected to represent the interests of the people of Couva South, and the Minister cannot use the privilege of the Parliament to mislead this Parliament. And I am
Member,
asking
I'm sure
you
you're
to
seeing me. Member, I'm sure you're seeing me on my legs. Member for Couva South. That kind of behavior is not to be tolerated. Press on.
Questions on notice. Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Caroni Central.
Thank you very much, Madam Speaker. In accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave, Madam Speaker, to move the adjournment of the House for the purpose of discussing a definite matter of urgent public importance, namely the health and safety issues affecting the Edinburgh Government Primary School. The matter is definite because the school is unofficially closed for 2 weeks now, and an OSHA assessment was conducted. The matter is urgent because of the possible health risks related to student exposure to pigeon droppings about which students have complained, and the matter is of public importance because students of Edinburgh Government Primary School are being deprived of their human right to an education.
It may be, Member for Caroni Central, that we both have a different script. But in any event, honorable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursue this matter under Standing Order 16 if he so wishes.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills, second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be read a second time. Madam Speaker, the bill before us is, quite simply put, one structured to allow for the establishment of a professional body to manage the category of professionals referred to as urban and regional planners. It is 61 clauses long and has attached to the bill, importantly, 8 schedules of forms and matters set out to referred to as prescriptive matters in a structured environment. The bill appears to be fairly long. It's some 43 pages long. But in essence, it's really quite simple. It is intended to form the structure to receive a category of professionals that have hitherto been unregulated and unsupervised in Trinidad and Tobago. The need for this particular bill is driven largely from another piece of law. And that other law is, in fact, Act number 10 of 2014. It is the act relating to the planning and development of land, and that act which repealed and replaced the Town and Country Planning Act. That act is now referred to as the Planning and Facilitation of Development Act 2014. That Planning and Facilitation Development Act was an act piloted by no less and competent a member of Parliament sitting as Minister of Planning at that point than the member for Caroni Central. The member for Caroni Central, in piloting that particular law, actually in piloting that law, I recall quite vividly in the Senate, gave the tribute to successive governments in the work that they had played in developing that law which came to the Parliament. Perhaps it is sensible, therefore, that I put onto the record that the Town and Country Planning legislation, which was born in 1960 in Trinidad and Tobago, and which was derived from the law coming from the United Kingdom, and in fact a very old piece of law coming from the United Kingdom, that particular law has stood on the books of Trinidad and Tobago and is still in effective operation. That is the planning laws as we have it in Trinidad and Tobago. Madam Speaker, the history of the introduction and birth of Act number 10 of 2014, which is in effect the law which causes us to bring this bill into consideration today, the history of that involves, of course, many sojourns into the need for certainty of spatial development. Trinidad and Tobago is an island state comprised of 2 islands comprising 1 republic. Land, therefore, is of essential importance to us. It is axiomatic that on an island, unless you are reclaiming land, that land is a finite resource. Madam Speaker, in the period 1988 straight up to 2011, there were a number of pieces of law that were attempted to be brought onto the books. there were a number of committees established to reform the manner in which we consider the utilization of our scarce resource, that is the land of Trinidad and Tobago, its foreshore and seabed, of course, being included. In 1988, we had the Town and Country Planning Act considered by the UN Habitat and also the United Nations Center for Human Rights Settlement. That was under the then Ministry of Planning and Mobilization. I believe that the member for Caroni Central was a part of that government, sitting in the NAR government then. In 1995, we had the IDB-funded Agricultural Reform Program. In 1996, we had the National Physical Planning Commission, which drafted a 1998 bill, the Planning and Development of Land Bill 1998. Then we had a series of bills, the Planning and Development of Land Bill 1999, the Planning and Development of Land Bill 2000, the Planning and Development of Land Bill 2000, the Planning and Development of Land Number 2 Bill 2000, the Planning and Development of Land Bill 2001. It wasn't until the management of structures in the period 2005 straight up to 2010 where there was a deep reflective considered approach for local government reform and also an introduction for property taxes that Trinidad and Tobago fully considered where it was headed to with this seemingly never-ending project of considering the reform of the Town and Country legislation. It was in that period of focusing upon local government and property tax reform and populating the role of valuations quite considerably so that you could take revenue from a property tax regime into local government to allow for development. It wasn't until that had happened that the government, and I use that in the sense of continuation and continuance of government, was put in a position in 2011 to consider a deeper form of reform. In 2013, a bill came to the Parliament. Certainly that was the Planning and Facilitation Development Bill. That bill was introduced into the Senate. A joint select committee was established. I was very pleased to serve as a member of that committee. The then chairman was the member for Caroni Central. And we spent a considerable amount of time, many sessions, engaging, I think, these considerations of some 17 entities and at least 12 meetings in that Joint Select Committee where we sat and we fine-tuned the development of the Planning and Facilitation Development Act, which is Act number 10 of 2014. That act, Madam Speaker, is essentially to provide for the orderly and progressive development of land in both urban and rural areas and to preserve and improve amenities. It is also to allow for the grant of permission to develop land and for other powers of control over the use of land, and also to confer additional powers in respect of the acquisition and development of land for planning purposes. Madam Speaker, that act, Act number 10 of 2014, the Planning and Facilitations Development Act, that act contemplates in a national spatial plan structure that there would be a decentralization of development consideration. There would be the utilization of the local government bodies to do simple developments, and then there would be a parent body that would consider complex developments. The act is also built upon a very important architectural cornerstone of the utilization of professionals. And the professionals that are intended to be utilized in this matrix are professionals to whom the privilege of operating in the system is provided. Let me explain what I mean by that. Part 7 of Act number 14, Act number 10 of 2014, is entitled Listing of Professionals. And the professionals who are listed are registered professionals in the persons of an architect registered under the Architecture Profession Act, established under the Board of Architecture, an engineer registered under the Engineering Profession Act, a land surveyor registered under the Land Surveyors Act, and an urban and regional planner registered under the Urban and Regional Planning Profession Act. Those professions are intended to be supervised by professional governing bodies. Obviously, We do have an Architecture Profession Act. We have an Engineering Profession Act. We have a Land Surveyors Act. But what we don't have in existence prior to the consideration of this bill is an act to form a body to supervise that category of persons referred to as an urban and regional planner per se. It was therefore true then, as it is now, that to operationalize the Planning and Facilitation Development Act, you must have a regulation of urban and regional planners. They are intended, together with other registered professionals, to have the ability to receive developmental plans, disseminate the developmental plans, all without prejudice to the powers and functions of the authority which has the overall and overarching authority effectively to intervene. But the cornerstone of Part 7 of the Planning and Facilitation Act, Act number 10 of 2014, provides a very important feature to give the way to developing Trinidad and Tobago in a more sustainable way. And that is, it requires professionals, be they architects, land surveyors, urban and regional planners, it requires professionals to be bonded, to have professional indemnity insurance, to stand pecuniary and professional liability on the record for developments that they put their signatures to and they certify from a fiduciary responsibility point of view. In other words, Madam Speaker, it is under this Act number 10 of 2014, the Planning and Facilitation Development Act, that we pin the professional liability in a very different way. It's true that professionals enjoy liability or have the obligation of liability, but it is under this parent act that we pin the obligation that you must put a bond for your professional liability. You must put professional indemnity insurance forward so that in the event that there is a catastrophe, a failure, or a claim, that you have an automatic recourse to the professionals who have certified this. Now, why do we want to do this? In a system of urban development and planning, you have to rely upon the integrity of the professionals in the system. The theory of law is generated such that law does not make sense unless you have a sanction. It's an ABC axiomatic principle. The example most often given in law school is, if you were to say that there's a law against walking on the grass, unless you put a sanction for walking on the grass, you will not have the cause and effect of stopping people from walking on grass. So effectively, urban and regional planners, as listed professionals, registered professionals, having location in Part 7, beginning in Section 73 of the Planning and Facilitation Development Act, number 10 of 2014, we must birth into law these particular bodies, this particular body of professionals, so that they can function in the system. Why? It's true that we have runaway developments in this country. It's true that people develop without planning permission. It's true that often the planning permission runs off at you. Under the existing law, the Town and Country Planning Act, there's a 4-year period of limitation. After 4 years of a development being into effect, you don't need statutory approvals because you are effectively covered by the statutory period of 4 years. Beyond 4 years, you've gotten away. This law now allows a continuing obligation upon the professionals. Therefore, there's a greater chance of enforcement. That's objective number 1 in terms of professional management. Obviously, objective number 2 involves us saying that the system of planning will be ameliorated because the professionals being bonded, being subjected to professional indemnity, they can have a participating role in giving the handout and approval process in an easier fashion. So we're ameliorating the system. That, in effect, Madam Speaker, is the background and connection of this bill to the Planning and Facilitation Development Act. I must say that the Planning and Facilitation Development Act, it was assented to, Madam President, on the 25th of, sorry, Madam Speaker, I often speak in both houses, I apologize. It was assented to and then partially proclaimed by legal notice number 151, Madam Speaker. And several of the sections have been brought into order. Taking the step of birthing the urban and regional planners is now a requirement so that we can put the listed professionals into proper order. So it is, of course, true to say that this bill had genesis in another parliament, that is the 10th Republican Parliament. This bill was found in other iterations. It certainly was found in the Urban and Regional Planning Bill 2012. The Planning and Facilitation Bill 2012 also had that. We did have a couple versions of the bill. We had this bill in a different form with a slight bit of amendment in the Senate on the 23rd of September 2013. It lapsed on the July 30th, 2014. It was reintroduced into the Senate on August 4th, 2014 in the 5th session of the 10th Parliament, debated on November 25th, 2014. It did not go to the House and it lapsed again. When it came up to the Legislative Review Committee under this government, there was a need for some improvement to the law, and at that point, we then settled upon this bill. Let me now turn to the purposes of this bill, Madam Speaker. This bill is currently drafted, as stated, as laid with a 3/5 majority. This bill, as I have advised the government, standing now after the benefit of case law coming out of Barbados and after consideration of a constitutional opinion, this law does not require a 3/5 majority. And I will be proposing that the 3/5 majority be deleted by way of an amendment in the course of committee stage of this bill. And I will give you the constitutional reasons for that in a short while. The law is effectively to cause the creation of something which many courts have considered. We are considering, Madam Speaker, the creation of a public body for a public purpose, for a public benefit. Those are the three public things that we're doing. Why do I say that? First of all, the bill proposes in its structure that we establish the council, and that is in Clause 4 of the bill. Clause 5 does a composition of council. Clause 6 does the functions of the council. And then we go into the considerations of licensing, the types of functions in their explanatory sense in terms of discipline of the profession, professional body management. But in creating this statutory entity in Clause 4 of the bill, we're establishing a body corporate to be known as the Trinidad and Tobago Council for Urban and Regional Planners. Clause 5 of the bill is very important. It then goes through the persons who shall be appointed. And Clause 5, of course, involves the establishment of this body via the minister. The minister is obviously the cabinet that is making this. We propose an attorney at law with experience in matters relating to urban and regional planning, 2 state planners who are professional members of the Trinidad and Tobago Society of Planners, and 1 person representing the public interest. And then there are 3 persons provided by the Trinidad and Tobago Society of Planners. These members effectively are appointed by a public entity. That public entity is the executive. That public entity is created by the legislature. That public entity is therefore a public body under the principles of law from a constitutional perspective. The functions at Clause 6 guide us. Madam Speaker, what time is full time in end? 36. Much obliged. The functions of the council are set out at Clause 6. And I want to put onto the record quite quickly what they are in sub-paragraphs A to I inclusive. Keep the administration of this act under review. Register and license persons to practice urban and regional planning. Monitor adherence to a code of ethics. Institute disciplinary proceedings in accordance with the provisions of the act. Review periodically application fees. Suspend or revoke the registration or license of an urban and regional planner, place or remove a name on the register, collect such fees as may be prescribed, perform such other functions as may be required by any other written law or reasonably incidental to. Stick a pin. When I make reference to other written law, I'm in particular referring to Act number 10 of 2014, which is the Planning and Facilitation Development Act. Madam Speaker, very importantly, the Part 3 of the law sets out, beginning at Section 15, that no person shall practice as an urban and regional planner in Trinidad and Tobago unless his name is placed on the register and he holds a valid license under clauses 16, 18, and 19. It then goes on in those successive clauses to effectively require that the applicant must satisfy the council that he has complied with the requirements of Section 15, Clause 15 in this case. You must be a citizen or a resident of Trinidad and Tobago, and you allow, in this case here, very importantly in Clause 16, Subclause 2, that CARICOM nationals can be the beneficiaries of admission in this purpose. And then we go on to state the level of experience that persons must have. If there's a master's qualification, it's 2 years experience. If there's a Bachelor of Sciences qualification, it's 3 years experience. We then go on to provide that urban and regional planners are entitled to have certain benefits, and that is set out in Clause 22. They can demand and recover reasonable remuneration. They can use the title. There can be recovery of fees and costs as civil debt in courts, that's in Clause 23. There can be revocation of license in Clause 25. We deal with the manner in which we have persons who are aggrieved of the council failing to have their licenses considered or rejected, renewed, or any other position. We provide for a system of appeals, and we put that due process consideration in Clause 27 for the appellate function coming to the Environmental Commission, where they can have the council reviewed on matters of refusal of licenses, revocation of licenses, suspension of licenses, or refusal of reapplication, and that the hearing may take place in such normal prescriptive fashion. We then provide in Part 4 for the register to be populated, but very importantly in Part 5, we provide for the committees of the council. The committees of the council are effectively bifurcated. First, there's a recognition committee, and then there is a disciplinary committee. And the recognition committee starts off at Clause 35, Clause 36, Clause 37, what they must do. They must list, they must liaise, they must assess and keep under review academic qualifications. They must look at the evaluation of posts, etc. There's an embodiment for a continuing education requirement, as many professions are now in the cusp of considering, the legal profession, the dental profession, the medical profession. And then we go on to the establishment of the disciplinary committee, which is then starting at Clause 43, going to 44, 45. And this disciplinary committee conducts disciplinary proceedings, inquires into matters, and makes recommendations to the council. We have, of course, the population of the disciplinary committee being an attorney at law of at least 10 years standing, appointed by the chairman, a member of the council, then 3 persons who are professionals of the Trinidad and Tobago Society of Planners, nominated by the Trinidad and Tobago Society of Planners, and have at least 10 years experience in matters relating to urban and regional planning. Part 6 goes on to the disciplinary proceedings, which are set out in conjunction with a consideration of the Code of Ethics. We go into the rules of the disciplinary process, the report in Clause 52 of the disciplinary committee, moving to the consideration of disciplinary sanctions, Madam Speaker, where we go in Clause 53 that the disciplinary committee may dismiss the complaint, revoke a license and remove the name, suspend the license for such period, reprimand the urban and regional planner, and that they must, of course, in due process provide reasons, etc. Very importantly, in Part 7, we prescribe offenses and penalties. And Clause 54 is important because Clause 54 criminalizes practicing as an urban and regional planner without a valid license. We then deal with miscellaneous provisions, staff of council, etc. Now, I've gone through quickly those provisions because I'm on the 3/5 majority, whether we need a constitutional majority for this law. I'm on the point of proportionality of the legislation, and I am going to deal with those submissions to treat with the aim and objective of the law, it being rationally connected to a legitimate purpose, the legitimate purpose being to make sure that planning and development in Trinidad and Tobago is conducted in a sustained fashion where we can actually have recourse to the mechanisms for compliance, and to ensure that the utilization of state land is managed. This bill contemplates, as the Planning and Facilitation Development Act does, that we will be regulating both the private and public sector. So, Madam Speaker, permit me to now, having recognized establishment as a public body by a public act, meaning an act of the government, not a private member's bill brought forward or a private promotion bill. Permit me now also, having set out that the functions are clearly public in nature, permit me also, having set out that the discipline and management and procedures, the committees as established, the method by which the body is funded, all of these things feed the characteristic of a public body for a public purpose with a public benefit. And I say that specifically because we ought to be warned by the following fashion of laws that guide us in this process. Madam President, Madam Speaker, the following laws are material for consideration. Number 1, the Dental Profession Act, Chapter 2954. Number 2, the Engineering Profession Act, Chapter 9001. Number 3, the Architecture Profession Act, number 9002. Number 4, the Land Surveyors Act, Chapter 5804. All of those laws are simple majority laws, all having been published and proclaimed after 1976. There is one iteration that perhaps can misguide people, and that is the law which treats with the regulation of the legal profession. The Legal Profession Act, Chapter 9003, was in fact an act of Parliament produced in 1986, Act number 21 of 1986. That law was passed with a 3/5 majority. However, Madam Speaker, that law was passed with a 3/5 majority at a point in time where there was an argument in Trinidad and Tobago that 2 particular rights could have been viewed to be infringed. Number 1 is the right to property, which is the Section 4A right of the Section 4 right of the Constitution. Number 2, the right to freedom of association, which is again an enshrined right of the Constitution. It is now safe to say, post the judgment in Surat, Madam Speaker, and in particular Baroness Hale's dicta, that it is now settled law at the court of highest binding effect for Trinidad and Tobago, the Privy Council, that not every 4 and 5 right of the Constitution needs to be treated with by virtue of a Section 13 provision, that is a 3/5 majority provision. And certainly, Madam Speaker, the obligation that we have is that we have to balance the rights of the public interest on the one hand versus the individual right on the other hand. It has also been settled, Madam Speaker, in an excellent decision which I wish to put on the record, coming out of the Supreme Court of Judicature Court of Appeal in Barbados. It's Civil Appeal number 20 of 2018. It's the case of Norman MacDonald Nurse, first appellant, the Attorney General of Barbados, second appellant, the Barbados Bar Association, third appellant, and Florence Nurse, the respondent. And this judgment produced and then settled on July 9th, 2019, is a seminal judgment which I commend for the records of Hansard, because it sets out the acknowledgement of the Court of Appeal that there is no intrusion on the right to freedom of association and certainly any property rights by a system of mandatory membership. This bill proposes that there is a mandatory membership. All people in the private sector or public sector, state, urban and regional planners, and private urban and regional planners, they must be members of the Urban and Planning Association that we are creating by this bill. The law as settled right now with relation to compulsory membership, Madam Speaker, says conclusively, number 1, the supreme law of the land is governing. That is Section 2 of the Constitution of the Republic of Trinidad and Tobago, that the supreme law is there. That feeds the argument in law of a presumption of constitutionality for any law. That has been recognized, of course, in umpteen dicta. Of course, top of the pack is Baroness Hale in the Surratt decision, and that is the Privy Council 2007, UKPC 55 at paragraph 45. Then again, there was also acknowledgement, and I put it on the record, in Wheel versus the Attorney General and another 2011, 5 LRC 610, and as well in the Privy Council in Boyce versus R, 2004, UKPC 32. And in that, we note that the Constitution continues to speak, statute continues to speak. We're looking at the interpretation of laws by the judiciary, and that the law is a living instrument. Madam Speaker, I wish to put on record, of course, as it relates to the freedom of association argument, that there are a number of jurisdictions that assist us in this purpose. There is the Attorney General of Barbados versus Smith, 1984, 38 West Indian Law Reports at paragraph 33, page 33, Williams J. in his dicta. And in that acknowledgement of a Trinidad and Tobago case, which I'm sure Couva South will be familiar with, Trinidad Island-Wide Cane Farmers Association versus Prakash Siraram, 1979, 27 WIR 329.
Please continue, Attorney General.
Those cases set out that the freedom of association argument is not only to be looked at as to whether you have a freedom to associate. It is not a one-way singular check valve. You also have an acknowledgement from the umpteen dicta the freedom not to associate. And in the context of this bill, whilst there appears to be in section 15 the creation of a mandatory system which prima facie offends, on the face of it offends, the freedom of association argument, what it says is that you are free to not associate. The fact that you must be a member to obtain a license is feeding the public purpose argument that it is good for a society such as Trinidad and Tobago within the meaning of section 13(2) of the Constitution and within the meaning of our proportionality tests as laid out in umpteen dicta, that you have the regulation of a profession. Number two, Madam Speaker, it also says that in your freedom not to associate, you must be guided by the fact that the payment of a licensing fee does not push you into any deprivation of your property. It is well settled that money is certainly property. That has been settled for umpteen years. But the payment of money for a public purpose is something which is in line with your constitutional rights. And therefore, the freedom of property or money argument does not arise. Madam Speaker, the dicta tells us that the rules, aims, objectives, functions of the body, the establishment of committees, disciplinary committees such as we have here, recognition committees such as we have here, are all in line with dealing with professional conduct, discipline, etiquette, etc., the upholding of professional codes of conduct as we have, continuing professional education, they are all in line with public purpose. Madam Speaker, public body performing public function in the public interest has also been recognized in the European context, in the United States, and in Canada. And I wish to put onto the record the European Court of Human Rights upholding of no intrusion on mandatory membership, offending the concept of enshrined rights of freedom of association or freedom of property. I put onto the record the case of Lecomte, Van Leuven, and de Maire versus Belgium, and where they considered the Ordre des Médecins, as they refer to it, that being particularly the compulsory position of membership into a professional body for doctors, the payment of fines, etc. And there was a very interesting paragraph coming out of that judgment, which says that the court notes, firstly, and in that case they were looking at the Belgium Ordre des Médecins, it is a public law institution. It was funded not only by individuals but by the legislature. Stick a pin, that is case on point, pari materia in this context. Two, it remains integrated within the structure of the state and judges are appointed to most of its organs by the Crown. That is exactly the situation here. Minister making appointment, the function for the disciplinary committee, the recognition committee, as we have in the bill here, again being on all fours with the particular structure here. It goes on to say that in this case here, in the Belgian context, it pursues an aim which is in the general interest, namely the protection of health by exercising under the relevant legislation a form of control over the practice of medicine. That is exactly on all fours with the purpose here today, Madam Speaker. Within the context of the function, requirement in particular to keep a register, etc., again on all fours with the establishment of a register in our case. Madam Speaker, the case of Lecomte was adopted in A versus Spain, application number 13750 of 1988, July 2nd, 1990. In that case, they were looking at the Saragossa Young Lawyers Group, again, a mandatory membership consideration, which was upheld by the European Court to not be an intrusion on the freedom of association. Madam Speaker, in the United States, of course, we have aid to this very purpose. The aim of this bill, the establishment of the structure in this bill, the public functions of this bill, the public interest of this bill, the regulatory bodies, the disciplinary bodies, the code of ethics. That case that leads that pack in the US is Latrop versus Donahue, 367 US 820, the Supreme Court of Wisconsin. And then we have the Canadian position echoing similarly. This is in the case of Levine versus Ontario Public Service Employees Union, 1991, 81 DLR, 4th at 545. And LaForest J., who gave that particular point, considered the context of the Canadian Charter of Rights and Freedoms, and they looked specifically at inherent limitations on the freedom not to associate. And I want to put on record this particular paragraph from LaForest J. It's at page 320 of that judgment. And I quote, "It does not necessarily follow, however, that Section 2D of the Charter protects us from any association we may wish to avoid. In a word, I do not think the freedom of association is necessarily a right to isolation. It could certainly not have been intended that Section 2D protects us against the association with others that is a necessary and inevitable part of membership in a democratic society, the existence of which the Charter clearly assumes. Realistically, too, as I will more fully explain later, the organization of our society compels us to be associated with others in many activities and interests that justify the state of regulation of these associations." The judge goes on to say, "In short, there are certain associations which are accepted because they are integral to the very structure of society. Given the complexity and expansive mandate of modern government, it seems clear that some degree of involuntary association beyond the very basic foundation of the nation will be considered constitutionally acceptable where such association is generated by the workings of society in pursuit of the common interest." I add on to the record RV Advanced Cutting and Coring Limited, 2001, again Dominion Law Report 205, 4th at page 385, and that reiteration of positions. So, Madam Speaker, the law as structured pursues a legitimate aim. In this case here, the bill being an act to create and establish a council for urban and regional planners. The legitimate aim is to populate a public body, in this case a statutory entity. Secondly, it is directly pinned to the legitimate aims inside of the Planning and Facilitation Development Act. Very importantly, in that act, there is a whole regime that professional organizations engage in a structure of devolved regulatory participation in the planning process, underwritten by bonds and professional indemnities. In that Planning and Facilitation Development Act, professional governing bodies are to keep lists up to date. They are to terminate the listing of professionals to be found at Section 81 of that Planning and Facilitation Development Act in certain circumstances. And then it goes on to give offenses where professionals, including urban and regional planners, if they don't comply with the obligations set out in the Planning and Facilitation Act, that there's a whole process of sanction. That parent act feeds into this bill. This bill, from a structural perspective, is A, create the council, B, populate the council, C, create a regime for licensing of urban and regional planners, creating the categories of licenses, the professional licenses including provisional licenses, temporary licenses, and permanent licenses, putting a prescriptive time frame for the licenses, causing the concept of continuing education to prevail, having a regime for relicensing and renewal of licenses, allowing for an appellate function to the Environmental Commission in the event that there is dissatisfaction with any of the renewal, licensing, or other regime prospects. Then this bill allows for the registration of urban and regional planners, the maintenance of a public register, how qualifications are managed, how striking out happens, what prima facie licensing looks like. We then go into the committees of the council, which are critically important to the constitutionality of this law, underlaying the public body for public purpose in the public interest, specifically the creation of the disciplinary committee and the recognition committee. We tie in the functions of professional misconduct in the context of the Code of Ethics, which is included in the schedules to this law. We prescribe out the various forms to make it user-friendly and easy. We allow for the process of disciplinary proceedings and the right of appeal. We deal with offenses and penalties. And of course, we promulgate the concept of regulations in paragraph 60. I'll be asking the CPC's department to cause a small amendment to clause 60. The amendment which I ask the CPC now on the floor to do is to please include a variation to section 63 of the Interpretation Act so that a breach of regulations will not attract a mere $500 in penalty, which is what section 63 of the Interpretation Act says if you're silent on a treatment otherwise. So we will propose two amendments to this law. Number one, remove the requirement for a 3/5 majority clause by removing the clause which sets that out. That will be clause 2. Number 2, amend clause 60 before it is renumbered to cause an amendment to section 63, a derogation away from section 63 of the Interpretation Act, and then, of course, to adjust by way of removal the need for the certification of the clerk, etc. Madam Speaker, I welcome the contributions of members opposite and certainly on our own bench, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to Provide for the Regulation of the Urban and Regional Planning Profession and Other Matters Incidental thereto be now read a second time. Member for Caroni Central.
Thank you very much, Madam Speaker. Madam Speaker, I think all members in this House would understand that the Member of Parliament for San Fernando West and Attorney General was speaking to a bill which we've had for some time, in which it is clearly stated that the bill requires a 3/5 majority for passage. And in his submission, in his presentation here just now, he spent his entire time arguing, or a significant proportion of his time in his presentation, arguing why the bill does not require a 3/5 majority. And it would be reasonable to say, in proportionate terms, that he spent most of his time speaking on what would essentially be the arguments for the amendment he intends to introduce than the substance of this bill before his amendment. And I really feel that the Attorney General has surpassed many earlier performances today. We've had a situation in which, while the bill was being debated, I challenged him on the issue of whether or not he would seek to remove the 3/5 majority requirement of that bill. And he proceeded to do that at the end of the debate of the bill, right here before this House. He has, in the public domain, indicated that it was his perspective and intention, in many cases, to seek to have bills that do not require a 3/5 majority come to this House. Now, I want to say something about that 3/5 majority because it's important. You see, if you build a logical argument on a false premise or assumption, it doesn't matter how logical the conclusion from that logical argument is. You would really be addressing the false assumption. And the Attorney General here comes to us and he tells us that the issues that are being affected, and because of various precedents in law which he quoted, have to do with the right to property and the right to freedom of association. But the truth is that this bill, Madam Speaker, the right that is being affected here and the right which then requires the 3/5 majority is the right to work. Did I disturb you when you were speaking, Attorney General? Madam Speaker, it restricts the right of the individual to work. This bill, in many ways, you know, the Attorney General started by saying that he was dealing with an unregulated or unsupervised profession. That's to say, the planning, urban and regional planning profession. And that is true. But before the Attorney General came here, one of the issues I was going to raise about this bill is that perhaps what this bill does is make the profession too regulated and introduces too much supervision and therefore too much potential for denial and exclusion. Madam Speaker, if you are not admitted to the planning profession, you cannot work as a planner. You cannot be connected through the planning and facilitation bill that he mentions. And you cannot, because of this bill, practice your profession as a planner. And the second thing is that if you are never admitted, you can never practice your profession. And it seems to me that something like this, which the planners, I know they had discussion with the planners on this matter, the planning profession, the government came to them and told them that they wanted to remove the 3/5 majority provision here. And the planners told them, no, we do not want that, because we want the bill to have the support of both sides of the House, and we want the profession to be supported by a 3/5 majority parliamentary decision. That was the original intent of the bill always. That was the original intent of the planning and facilitation bill. And what I don't know if he negotiated with the planners or the Society of Planners in order to come here to do this, but I would think that they would not be pleased about the fact that what he is doing now is making this a very partisan bill. And I think that is contrary to everything that needs to be done in terms of national planning in Trinidad and Tobago. Now, this bill establishes the council, and it creates the council as a legal entity. Madam Speaker, that is what it was created. That is what this bill is for. And originally, it indicated that it was inconsistent with Section 4 and 5 of the Constitution. It still is, because it restricts the right to work by insisting on a gatekeeping role for the Council of Urban and Regional Planners. So it insists, in our view, we have to insist on this side, Madam Speaker, that the Attorney General cannot come just so and change the game, so to speak. I want to repeat the fact that it is a known fact that the government approached the planners to remove the need for a 3/5 majority, and that the planners understood the wisdom of not doing that and advised the government accordingly. And I would like the Attorney General to indicate, when he does his winding up, whether in fact he violated the wishes of the Society of Planners. Now, this bill was originally brought here and partially debated in one of the houses in 2013 and a debate, I think, in 2014. And there have been amendments to that bill, so there are changes to the bill that has come here. Clauses, in clause 3, pages 2 to 6, you deal with definitions. Some of the definitions have been changed from the original bill. And in terms of the qualifications, we have the same kinds of problems here that we had and we debated when they came to amend the Planning and Development Bill, Planning and Facilitation of Development Bill, which is that the issue of qualifications and accreditation and so on. I mean, they spend so much time on this thing. It has become so convoluted. I don't know how this is going to be put into practice. The definition now includes persons who have graduated from UWI in an undergraduate program, because the bill wants to mandate an undergraduate degree. And the amount of angles of insistence on accreditation that are mentioned in those pages 3 to 6, I mean, makes you wonder what is the thinking behind all this insistence on qualifications and accreditation. Now, there are things that are wrong with the bill in terms of simple writing out of ideas. So, for instance, in 6C, is on page 6, sorry, in part 1, what is the clause? The clause is 3. It says development management activities with respect to the implementation of relevant government policies. All right, I mean, I would think a more elegant wording would be development management activities in alignment with relevant government policies, because I don't think the planners are going to be implementing anything here. In terms of the structure of the council, in our original bill of 2014, there were 3 persons nominated by the minister, so that the majority did not come under the direct appointment and jurisdiction of the minister, and they have changed it to 4, so that the government minister, through the cabinet, would actually control. There are uncertainties here. For instance, 1 person representing the public interest. It does not say whether that person should in fact be a planner or simply a citizen of whatever profession representing the public interest. It is not clear on this. And the minister appoints the chairman and the vice chairman. Then you have the functions of the council, which are really functions and powers to register urban and regional planning professionals, ensuring that these professionals maintain their status, annual updating of registration, code of ethics, and standards. And what we have essentially, Mr. Deputy Speaker, what we have here, the Attorney General talks about a public body, but what you have here is a kind of quasi-state board, because there's ministerial control directly, whether it comes from cabinet or not, it doesn't say so, but there's ministerial control through ministerial appointments. And when you look at the system, you see that this is a quasi-state body. And I draw that to the attention, because you may say public purpose and public benefits, but it's a quasi-state body. Now, look at some of the problems with the bill again. On page 12, it says here in this particular phrase that you must have, that the planner must have a certificate of good character from the jurisdiction in which the applicant has resided for the last 6 months. Does that mean a police statement of good character? It doesn't make it clear. And then the second one, it says on page 12, evidence that the applicant has not committed professional misconduct that brings the professional planning body in the jurisdiction of which the applicant resides into dispute. Now, how do you prove that you have not committed professional misconduct? Do you have to get testimony from people? Do you have to get it from some other professional body? I mean, how do you go and prove to people, unless you get a police certificate or something like that, you're a good character, or that you have not done anything wrong in the profession? And besides requiring all manner of accreditation, the Accreditation Council of Trinidad and Tobago is mentioned again as having jurisdiction and control over the acceptability of qualifications in the profession. Now, when we introduced the bill in 2014, Mr. Deputy Speaker, the People's Partnership then, the UNC, sought to develop this bill in close collaboration with the Trinidad and Tobago Society of Planners, which is the major professional stakeholder. So, in general, our disposition was to support this bill. But when you come here and having looked at the bill that they put here and the Attorney General comes with a different set of assumptions, a different approach, a withdrawal of the 3/5 majority, I mean, I don't know how we could support what is really a hijack of the parliamentary process and a hijack of a bill that is meant to establish a professional entity in order to guard the proper jurisdictional and reasonable, sustainable development of the land space in this country. You know, I find this very difficult to, I cannot conceive how we could do that in the first place without warning. Yeah. I don't understand how we can do that without warning. I mean, parliamentary conduct, I mean, requires one to behave in a certain way. You know? So,
Speaker, Standing Order 48.6. Mr. Deputy Speaker, Standing Order 48.6, please.
what is
Overruled. Proceed.
that? Thank you, sir. Let us discuss a little bit the context within which this was developed. In addition, there are a number of things here. When the Minister of Planning and Development brought the Planning and Facilitation of Development Bill for amendment, Mr. Deputy Speaker, it took her 3 years to bring those amendments. And there has been no proclamation of any additional part of that planning and facilitation bill except what we proclaimed in October 2014. Okay? So that there has been no further or additional proclamation of that bill since then, notwithstanding the amendments that they made. And we objected to many of the amendments. Many of them were simply had to do with these issues of qualifications and so on. So they took 3 years to bring that for amendment. It has not been proclaimed. The second thing is this one took 4 years to bring these amendments. And the real amendment that they wanted to make is not in the bill. It is to take out the 3/5 majority. That was the real amendment that they wanted. So the second issue I want to raise is that there's an issue here of ethical behavior. It is, the Attorney General mentioned it in the issue of indemnification, and I think he said there's a bond. So, and this is meant to regulate the system and the general public good, so to speak, from unscrupulous or unethical behavior by professionals. But the sanctions in the bill, Mr. Deputy Speaker, only address the right to practice. What about compensation for those directly affected by unethical behavior? Because there's going to be a cost to them. If I have a development and you are a planner and you screw it up and you are indemnified, and even if the profession takes sanctions against you, what about my position in terms of loss? And there are many developers on that side. Now, during the meetings in my time, in our time of the UNC in office, and in my time as Minister of Planning, we held discussion with the built environment professions, including engineers, architects, valuers, surveyors, planners, on a collective approach to making that kind of insurance affordable. We had also initiated dialogue with the Joint Consultative Council from the construction industry on a structured approach to the matter. I think the Attorney General, since he's piloting the bill and the Minister of Planning and Development is not present, I think he owes us an explanation of whether there has been any progress on all of these matters, which was started as consultations in 2013 and 2014 and continued into 2015. Now, when this bill was first introduced in 2014, it was meant to register just 100 or a little more than 100 planning professionals. And because these are very important people influencing the profession, and this profession affects the use of people, the use of land, the use of buildings, the use by people of land and buildings. And it was introduced in parallel to the Planning and Facilitation of Development Bill of 2014, which is now an act. This was partially proclaimed, as I said, in October 2014. And what we have here is that all the positive bills that we introduced, the procurement bill, that was brought here for amendments, it is not yet proclaimed. The planning and facilitation bill, it was brought here for amendments. It has not been proclaimed further than it was originally proclaimed by the People's Partnership. And this bill here, given all the things and what are really blocks and hindrances with the Planning and Facilitation of Development Bill, even if we pass this bill here, what difference would it make in terms of the actualization of the intent of these very important bills that have to do with land development and the management of land in a sustainable way? Now, the Planning and Facilitation of Development Bill, Mr. Deputy Speaker, introduced what we call a registered professionals regime. And that is what the Attorney General was referring to in there, in which development was classified as either simple or complex. Applications for complex development under that act, which is what makes this necessary, this bill before us necessary, can only be submitted by registered professionals, so that you can get a draftsman or you can get somebody else to help you to do a simple development, which is a development of 20 buildings or less, or for a house or for an expansion to an existing building or so on. But for a complex development, which includes buildings on land beyond 5,000 square feet that consists of more than 2 stories, 3 stories and more, and land development, including more than 20 buildings on this parcel, you need to have planners involved in that under the bill, so that you need to have this, so that the proclamation of the Planning and Facilitation Bill would need and require people such as these professionals in order to support the execution of that bill. All right? And there are other professionals that are involved, engineers, architects, surveyors, etc. And as the Attorney General correctly said, because they were not registered as a professional body, we need to make that right. So the intent of the bill we have no problem with, and we were prepared to support that. But and the Attorney General mentioned spatial development and so on. And all of these bills, all of these pieces of legislation, the whole business of development relate to a number, well, take into account and must take into account a number of very, very connected things. The Planning and Facilitation Bill, the National Spatial Strategy, which was laid before this Parliament in 2013, the Planners Bill, this particular bill that we have here, an act to establish the Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession. It requires, Mr. Deputy Speaker, local government reform, something which is now before a joint select committee and has not been completed, because the Planning and Facilitation of Development Bill envisaged, and we started it during our time in 2013 and 2014 and continue in 2015, the transfer of all management of simple development applications under the jurisdiction of local government in Trinidad and Tobago. It also requires geospatial information systems. And for that, we had established a National Spatial Development Council, which has been eliminated. So, for instance, when they talk about an undergraduate degree for a planner, that undergraduate degree does not have to be an undergraduate degree in planning. There's no such thing in Trinidad and Tobago at the university or anywhere else. But you could have a degree in environment, you could have a degree in GIS, you could have a degree in geography, all right? You could have a degree in anthropology for that matter. And then you go, it's like the MBA. The people who do MBAs do not necessarily have a degree in management or economics. They go on to an MBA from whatever, they might have psychology below. All right?
Honorable Member, your initial speaking time has elapsed.
Yes.
You have an additional 15 minutes. You care to avail yourself?
Yes, thank you,
Proceed.
sir. All right? It also took into account regional development plans and the principle of devolution and decentralization, to which our government under Mrs. Kamala Persad-Bissessar as Prime Minister was committed. It took into account that we had LED or local economic development plans in local government. Not the bulbs. It took into account that we had policies to facilitate development and to stimulate construction, that we had social and community development strategies that were driven by a human development atlas, which basically dealt with the demographic realities of 14 regions and Tobago. We had a strategy which involved growth poles and economic development zone. We had plans for a road network and system and public infrastructure development projects. It is with all of these things in mind that this bill was rescued after a 10-year hiatus in the Parliament. That planning and facilitation bill, the Attorney General spoke about its evolution, but he did not highlight the fact that it lay languishing for 10 years and nobody would touch it, because they did not want really to change the development paradigm in the country at all. They suppressed the development of land in this country for years, and operating on a Town and Country Planning Act that dated back to the Eric Williams era. People don't realize that Eric Williams was the first Minister of Planning of Trinidad and Tobago under a national government. And so all of that, you know, you have to have a view of how these things happen and how they connect and interrelate. And to come here today, just out of the blue in the arbitrary fashion that is generally an aspect of governance under this particular regime, you come here and you just change the rule just like that and you say no more to 3/5 majority. I don't know, maybe he'll get up and say that in his wind-up member for superior leader of the opposition. And now, what we had done a number of things, you know, for instance, we had dealt with the backlog in Town and Country Planning. We had made it, you know, in 6 weeks you get this, in 2 months you get this, right, in 12 weeks you get this, etc. All of that is now shut. I hear in the Tunapuna Planning Office, you have a backlog from about the end of 2016, Mr. Deputy Speaker. That is what I met when I came in. I mean, there are literally thousands. And we were able to do it and rationalize it and so on. And these planners were meant to be part, when you pass the legislation, of the process that would quicken the process. Because when a planner does a plan that is complex, you take into account that this is a professional, so you don't have to take it through the level of scrutiny that you would, all right, if some amateur simply sent it in. And so we have waited now almost 4 years for these minor amendments to come here. And the real amendments are that they have complicated the educational requirements to be a planner and made it extremely convoluted. They have restricted in an exclusionary way the admission process for establishing members of the planning profession. And thirdly, given what they have done with the other elements of development to which this bill and the planners as professionals are critical, the value of this bill in terms of any kind of actual development work is almost negligible. You know, the last time they came here, they took simple development. We had simple development and complex development in one part of the bill. They separated out, and by the time you read the bill, you don't know which one relates to which. And it's the same thing here to achieve I don't know what purposes, Mr. Deputy Speaker. So I asked the question, what is the state of backlog, and whether this bill will be proclaimed together with the other bills in order to facilitate the process of development in this country. You know, if you...
But for Naparima, right, your comment is reaching my ear, so please, proceed.
Thank you very much, Mr. Deputy Speaker. The as I indicated before, we had a hand in this bill. But we had a hand in this bill together with other bills that were really for the reform of the economy and of governance in this country. When you take procurement bill, when you procurement reform, when you take the planning and facilitation bill, when you take this bill, when you take the other things that I mentioned with GIS, etc., with devolution of power, decentralization, and so on, with spatial planning of a certain kind, we had a vision for this country in which all of this thing fit. And that vision was led by a lady, the first lady Prime Minister of this country, Mrs. Kamala Persad-Bissessar. But all of that has been undermined now by the lag in time, by the amendments that make no sense, by the subversion of the 3/5 majority process, which the planners wanted. And I do not see any enlightenment in the development of Trinidad and Tobago, really, and in the development framework for Trinidad and Tobago. In fact, you don't even see the construction happening in the country. There continues to be, under this regime, a suppression of land development, in my view. There are many things that we pass, for instance, multiple family dwellings on 5,000 square feet that are not being facilitated now. We made decisions that created the conditions for taller buildings to go up in different parts of the country. All of that has been suppressed by this particular government. And really, when you think about it, their approach to development is development control. Their approach to development is development control. They want to control the process of development in the country. They want to control who develops. They want to control who gets permission. They want to control who gets into the planning profession and therefore becomes aligned to the development process. And their approach to development, Mr. Deputy Speaker, is development control, pure and simple. It is suppression of the many for the benefit of the few. And the end of that is skewed development. It is inequality. It is a gap between the rich and the poor that grows. And it is development which guarantees, if we do not correct it, that during the process of development which proceeds in that way, you are going to have a massive rebellion against an oligarchic elite in Trinidad and Tobago. Thank you very much.
I recognize the member from Aruga Tableland.
Mr. Deputy Speaker, good afternoon. Good afternoon to members of the House on both sides. It is my pleasure to join this debate on this act to establish a council for urban and regional planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto. So, Deputy Speaker, before I begin saying anything argumentative, let me first of all commend the Attorney General for piloting this bill. And let me, of course, commend our Minister of Planning, the nation's Minister of Planning, for her role in framing the bill. So, Deputy Speaker, I perused this bill before, but I read it more in depth today, understanding that I would have to respond to the first speaker on the opposition side. And I noted a number of things about the bill. And I will couch them this way, Mr. Deputy Speaker. By now, I have lost count of the number of bills piloted by the Attorney General. There have been so many. And I sit just over his shoulder, and I get to listen to all of them firsthand. So I've noted a certain pattern of discourse when it comes to him presenting a bill
and interrogating its internal workings. And he has a process in that he generally talks about the bill in depth in terms of all the clauses and what the clauses do and what they mean and the arguments centered on them. And that generally makes up the majority of his discussion. So, Deputy Speaker, I noted a little difference in what the Attorney General said today, in that he sort of eschewed, he elided that kind of in-depth analysis, clause by clause concern, clause by clause interrogation, clause by clause explanation that he normally does, and there's a very simple reason for that. So, Deputy Speaker, this is a very long, short bill. It has 62 clauses. Most of them are as short as the title, if not shorter. The thing is almost as long as a court's brochure. It's very, very matter of fact, very utilitarian. It just gives what it's supposed to give, and it doesn't get into too much of the meat of anything. So, Deputy Speaker, and given the nature of the bill and given the nature of the act, and given the very specific intent for which it has been engineered, that kind of discourse by the Attorney General was absolutely understandable. So he spent more time discussing the legalistic history of it, the evolution of the thing, and then explaining what it means and how it pertains to us. And that is absolutely fine. And I was very much okay with that. And then, of course, Mr. Deputy Speaker, I had to listen to the member for Caroni Central. Now, it was absolutely obvious that the person who would be responding to this, to the mover of the bill, would, of course, be the member for Caroni Central. He was, the Minister of Planning under the previous regime. And anything that seems to be developmental, he is usually the point person in terms of responding. And of course, if one has to come after, one wants to predict, forecast what might be the direction of the discourse, in other words, in order to ensure that you can say something coherent. So, Deputy Speaker, I expected the typical UNC response, which is, we had a plan. We had a plan. Whatever bill the PNM presents or the government presents on this side, Mr. Deputy Speaker, the response was, well, we were going to do that. We had a plan. We had discussions about it. We were talking about it. We were thinking about it. And what, of course, would have been done? Absolutely nothing. Nothing. Mr. Deputy Speaker, they used to be called the box drain government. I am on record here in this parliament stating that that is actually high praise.
Silence, please.
Mr. Deputy Speaker, that is actually high praise. Being called the box drain government means that you actually built a box drain, and we have no evidence of that. So they should more aptly be called the we had a plan government. Mr. Deputy Speaker, I know I was going to hear, well, we had a plan. We had discussed it. We were going to do it. And I was prepared to respond to that. So, Deputy Speaker, what I heard instead was an argument with so much depth, it would not fill a teaspoon. So, Deputy Speaker, the Member of Parliament for Caroni Central has been in Parliament since I was in primary school. I was in short pants, Mr. Deputy Speaker, when he was already sitting here. And I would expect that if he were to come and present something that is, really down his alley, that even if we disagree that there is some profundity in it, what we got was shallowness that would not drown a fly. Mr. Deputy Speaker, the member for Caroni Central comes this afternoon, and I am absolutely sure that when the member for San Fernando West, the Attorney General, Honorable Attorney General, mentioned that he had removed the 3/5 majority, the Deputy Speaker.
Outshot.
Okay.
They're disturbing.
Members, please. Members, each one of you will have the opportunity to enter the debate, right? Right, as I was saying, each member will have the opportunity to enter the debate, right? Once you acknowledge, I will so grant you the favor. But I will not continue to tolerate, again, the outbursts across the floor on both sides. Fair enough? Proceed.
So, Deputy Speaker, the member for Caroni Central couches his argument, his rebuttal of the brilliant presentation of the Attorney General, in the fact that this bill constitutes an infringement on the right to work. Even I, Mr. Deputy Speaker, after listening to barrels and tons of ridiculous discourse from that side in the last 4 years, didn't predict that that would be the direction of the discussion. That we are infringing on the right to work. So, Deputy Speaker, being a planner, urban or regional planner, is a highly technical, very specialized skill that requires years of study, years of training. It's obvious that any responsible government,
Leader of the House, Chief Whip, I just spoke. And as two senior individuals in the House, please. Right, you all know the procedure. You all can go and have a chat to the back. Proceed.
So, Deputy Speaker, it is obvious that any responsible government, any responsible state, any responsible entity dealing with something as important as planning, particularly in our historical context, would want to be very certain of the quality of person who enters the profession. We'd want to be certain that they have the requisite skills and understanding, because the consequences of not having that would be dire. So, Deputy Speaker, by the same logic, then we should allow anybody to practice medicine. Anybody should be a surgeon.
True.
By the same logic, anybody should be a pilot. If it is that the government is wrong, pardon me, if it is that the government is wrong for ensuring that something as critical as planning has a set structure, a set of prerequisites, a set group of expectations.
Couva South, Laventille West. This is the last occasion I'm going to come up on my legs with regards to any outbursts. Proceed.
Mr. Deputy Speaker, if that is in any way logical or sensible, then all the professions we have, we should have no requirements for them. We should allow anybody to do anything, and we should have a state of reasonable chaos. By the same logic. There is no way that that could be a logical, sensible discussion. A logical, sensible argument, particularly by someone who, for whatever reason he decides, prides himself on understanding planning. There is no way that that could be a logical argument. That is a doorway to chaos. So, Deputy Speaker, that makes no sense. There is no way it could make sense. That is the feeblest of arguments and discussion. He goes on to base the rest of his febrile argument on the removal of the Chief Whip's majority. So, Deputy Speaker, I am not legally trained, neither is he. I have no pretense to understand constitutional law at any level beyond a layman, even though I have very good comprehension. But even I, unlike any member on that side, I am versed in comprehension. Unlike any and every member on that side, I am versed in comprehension. So, Deputy Speaker, I am very sure if you were to go through the report books of the members there, if they ever pass comprehension, it's very generous teaching. But I move on. So, Deputy Speaker, I am very sure that the member for Caroni Central was very happy when the Attorney General stated the removal of that Chief Whip's majority, because then he had something to talk about. Well, Mr. Deputy Speaker, before we get here, before any law arrives in this Parliament, there's a process. There's a process of assessment, framing, shaping, and assessment. And sometimes things change, and sometimes the views of things change. And if the Attorney General, in his own wisdom, understanding the Constitution and the law and the requisites of this Act, see it fit that the Chief Whip's majority is no longer required, and he accepts that that change ought to be made, then I see no problem with that. But of course, there are ghosts. What they see on the other side are ghosts in the machine, and bogies and duens everywhere, so that now it becomes dictatorship and creeping dictatorship and wanting to control everything. So, Deputy Speaker, laws go through a process of transformation. Before they get here, they go through a process in the Parliament, they go through a process after the debate, after they've been passed into law. And that is the natural order of things. So, Deputy Speaker, the member for County Central suggested that the government had gone surreptitiously to talk to the planners, to try to convince them of the rectitude of removing that three-fifths majority. I am condensing your discussion. Given the suggestion that we were doing something underhanded, so Deputy Speaker, no such thing happened. But even if that were the case, even if it were the case, Mr. Member for County Central, that the government did go and have a discussion with the planners, there is fundamentally nothing wrong with that. This is the same party that every time government brings forth some idea or some concern, talks about consultation. Did you consult? How many consultations did you have? You didn't consult enough. It's government by dictatorship and one pack of inane discussion. So even if what the member suggested, Mr. Deputy Speaker, was true, that the government had gone to have a discussion with the planners as to the three-fifths majority, if that were the case, there'd be nothing wrong with that. Part of legal framing is consulting with those who will be affected by the law, and they have been on record in this Parliament talking about that ad nauseum, so that now that would be a problem. Is the height of hypocrisy. It is the height of hypocrisy. So, Deputy Speaker, the member went on to talk about some really, really inane things. Talked about the inelegance of the language. Mr. Deputy Speaker, the act is by its very nature and very intentous. It's meant to be very specific. It's meant to couch certain things, and it does that. Then, of course, there is the oft-repeated bogey of ministerial intervention. So there is, of course, a problem that some of the members of the council will be appointed by the minister. So, Deputy Speaker, exactly, why not?
Every profession has that.
Why not?
Every profession has that.
That is the norm in a number of areas, in a number of societies, in the Commonwealth and everywhere. Politicians appoint people to specific posts, and that is the nature of things in democracies. But of course, given that the PNM government is in charge, there is a fright and a fear and the specter of ministerial appointment. I will say this, Mr. Deputy Speaker. There was a time in this country to be very afraid of the nature, intent, and direction of ministerial interference. And that time was between 2010 and 2015. It has not been the case since December 7, 2015. In fact, it has been quite the opposite, where ministerial control has reverted to what it has been historically and what it should be in the future. So any fear of ministerial intervention, ministerial interference, that resided in the past. And we have put that past to rest. So, Deputy Speaker.
Couva South. Member for Couva South. I am hearing you. Please. Proceed.
So, Deputy Speaker,
okay, I understand. Proceed.
So, Deputy Speaker, I am accustomed to being interrupted by Couva South's incoherent mumbling. It does not affect me, and I will move on. So, Deputy Speaker, the member raised some issue with the fact that the act required those who would be planners to receive a certificate of good character. He made some issue with the fact that the act requires that there be no issues of misconduct. There be no questions of misbehavior in your profession, on your resume, and that these are problematic. I cannot fathom how. If you have someone who is doing something as critical as planning, you want to have issues of character, you want to have issues of of professional rectitude? Why is this problematic? The member is simply grasping at straws, trying to make a very empty and vacuous argument. So, Deputy Speaker, no, there is no way that that can be an issue. That can be problematic. That should be something that you want to ensure. Hence, it's in the Act. I can't understand how that becomes an issue of consternation. So, Deputy Speaker, he makes a critique about this being part of a larger framework of acts centered on land issues, and that these acts have not been actualized. So, Deputy Speaker, I am very confident that the Attorney General knows his job, understands what he is doing, and is going to ensure that this suite of land laws become operational, and we bring some sanity to the chaos that exists in this country in terms of how land is organized and regulated. I am absolutely certain of that. I am confident in the Attorney General and his abilities. As a Deputy Speaker, the member talked about local government reform, and that for this to become active, it requires that reform to become realized. So, Deputy Speaker, he is, by his own admission, aware that this is in a GSA at the moment. It is being ventilated upon, and that it will become enacted into law. So that process is already underway. That critique also falls empty. So, Deputy Speaker, he ended his discussion by talking about this act as though it was something very sinister. Government is attempting to suppress land use, attempting to suppress those who can get involved in development, attempting to ensure only certain people get involved in things, making a kind of a very Machiavellian statement. So, Mr. Deputy Speaker, we inherited a situation of chaos from the previous regime across the board. There is no area that was not infringed upon by the chaos that they brought as part of their meandering governance. So, Deputy Speaker, this is just one example of a wider set of examples of us trying to bring order where chaos existed. It is not intended in any way to subscribe who can and cannot become involved in land development. That has never been the way of this government. That has never been the way of the PNM. It will not be the way. So that kind of Machiavellian, kind of sinister sounding statement really has no place in this discussion and has no place here. So, Deputy Speaker, laws have resonance beyond the clauses and the statutes and the implementation themselves. And this particular law is of great significance now, despite its narrow constriction, and the resonance of it will be felt for years to come. But it battles against a very interesting problem. So, Deputy Speaker, if you are honest and critical about the nature of development in this nation, it is understandable, and clearly so, that we have a historical and cultural problem. And I have been on record in this parliament over and over saying that it is very difficult to attempt to fix a problem that you don't really understand the root of. I was very happy, Mr. Deputy Speaker, when the Attorney General couched his discussion today in the evolution of this idea legalistically. And I thought that was important for the wider understanding in the chamber. I thought it was important for the wider public understanding that he would take the time to explain the legal evolution of the idea and how we got to this point. But that legal evolution, there's another explanation that exists in other places. So, Deputy Speaker, we have a particular and peculiar problem when it comes to development in this country, because we really have two different histories of development. And they're sort of centered around the way the state has operated, and we need to understand that. Or the implementation of this will not have the effect that we want it to have. But this law in itself is battling against that historical problem. we had two different kinds of development. So, Deputy Speaker, we were a colony until 1962. The state was a colonial state. The state was, by its very nature of being colonial, antagonistic to certain kinds of development. So the state, as a colonial state, had a state-centered development. And it was very, very, very restricted, and you could see that pattern in almost anywhere you had a colonial relationship. So, Deputy Speaker, we have a history of very centralized development that is not peculiar to Trinidad and Tobago. It's something you find in almost any colony. Very simply, we have a capital city, Port of Spain, which is what you would call historically a primate city, because that's how colonialism operated. It would have a central point where everything was located, where the power center was located, where the persons who worked for the colonial government usually lived and worked, and everything was centralized there. So development was centered there. Everywhere else was less significant. Everywhere else was hinterland. So, Deputy Speaker, we had a colonial state that was very antagonistic to any kind of development that it did not control. It did not steer. So, to have development, you had to almost do it in the face of the state. You had to do it in a way that was antagonistic to the state. So, Deputy Speaker, we have communities in this country that are developed or have evolved out of something called free villages. Because in the wake of emancipation, there was an intent to keep the enslaved on the plantation. And you could only develop by basically going to squat land and creating villages and communities where none existed. That was development antagonistic to the nature and the intent of the state. So we have two histories of development here. We have one history, which is state-centered, state-controlled. We must dominate development. We must say what is and what is not development. And we have another legacy of people who, because of the actions of the state and the intent of the state, are forced to develop basically as an affront to the state. We have both those legacies here, Mr. Deputy Speaker. In 1962, the state becomes us and we become the state. The colonial government is gone, but both legacies remain. And because of that, Mr. Deputy Speaker, we have a culture here which is antagonistic to any kind of regulated development. That's why people feel they have a right to build anywhere, whatever they want, how they feel. So, Deputy Speaker, if you ask every member of parliament here, any member of parliament, they will tell you that every week they get complaints, that some developer, unregulated, no tongue and country approval, has built something somewhere, blocking off some natural watercourse, blocking off some road reserve, building on some aquifer, or attempting to, building where they're not supposed to build. And that person generally feels that he or she has a right to do that simply by the provision of owning the property without any kind of regulation. And that's our history, and that's our culture, and that's the way we generally operate. So, Deputy Speaker, when societies evolve, as ours is evolving, they become more complex, they become more complicated, they have to develop systems to deal with that complexity in order to maintain order and to ensure progress. That is what we're doing here. We've come to the point on one hand, Mr. Deputy Speaker, where we have to understand in high definition the consequences of unregulated development. So, Deputy Speaker, the members of Parliament from Central Trinidad should be the ones most interested in this act. Sure. They should be the ones. They stand to benefit the most. Because every year, if they are MPs who are effective and who actually live or are in any way concerned with their constituents, they would know that one of the root causes of the flooding that engulfs much of Central Trinidad, much of South Trinidad, is a consequence of unregulated development. They live that every year. They live that every year. The same thing. The same thing. So, Deputy Speaker,
Silence.
they should be the ones most interested in this act because they stand to benefit. If we can limit, we can restrict, we can control, we can direct the kind of development we have here, these members on the opposing side stand to benefit. Everybody stands to benefit. So, Deputy Speaker, but this is also a projection for the future. We live on a very small land space, as the Attorney General said very, very coherently and clearly. We have a limited land space. At some point, it is going to become the fact that the buildings we build, which 4 or 5 stories, 2 or 3 stories, will become passé. And simply because of space, we will be required to build taller and taller buildings out of necessity. You don't want someone who has questionable acumen, questionable skills, questionable abilities, questionable accreditation, supervising, vetting, or it's part and parcel of it. It's part and parcel of it. You don't want you don't want a planner, you don't want planners who are not competent having any part to play in that process. There are severe and significant safety issues. So, Deputy Speaker, planning is a very specific skill. It requires acumen, it requires ability, and to ensure that we have the kind of planning we need here to take us into the future, it requires regulation. There is absolutely nothing wrong with the government creating a council to ensure that the planners are organized properly, regulated, competent, able to carry out their duties. There is absolutely nothing wrong with that. The specter of this becoming some sort of state board is overblown. It is the case that professions have professional bodies that supervise them. That is the norm and has been the norm for centuries and will continue to be the norm. So, Deputy Speaker, we are a small island developing nation with finite land space and dwindling resources. The state, on one hand, and I would suggest on the other hand, even the private sector can no longer afford the luxury of bad development, poor development, misplaced development. We've come to the point in our history where that kind of thing can no longer be sustained by either the private or the public sector. It is to the benefit of all of us that we have this kind of regulation. It is to all of our benefit that we have this council in place. It is to all our benefit that we ensure the right people with the right abilities and acumen become planners. It is to the sustainable development of this nation that we do this kind of thing. So it was my pleasure, Mr. Deputy Speaker, to stand in support of this act. This afternoon, I reaffirm my support for the Attorney General, Minister of Planning, in their framing of this. I see the importance and relevance of it, particularly in a community where it is still the norm that people build houses in places where houses should not be, and then suffer the consequences, and then I end up having a very difficult discussion with them. So, Deputy Speaker, this act, as simple as it is, as narrow as it may appear, is important to all of us. And I thank you.
I recognize the member for Tabakit.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I am very happy to join this debate, but again, since it involves matters of development, it is well known that I'm a developer, and again, I declare, my interest as a developer in these matters. So that, if I say things that may sound like it serves my interest, it's unfortunate, but it's part and parcel of the trust of the debate that has to take place here today. Mr. Deputy Speaker, I expect quite a lot more from the member for Moruga Tableland, but every time he speaks, it's so convoluted that I wonder whether he's really speaking about the bill, what is he speaking about, his historical context, and so on. But today, his contribution was vacuous, irrelevant, in my view, unbecoming of his training, and an embarrassment to the constituents of Moruga Tableland. Really and truly. I expected much more. I expected him to really put into context the importance of this bill and planning so that he could have raised the stature of his constituency and shown how they could be developed into a first world society as part of the new world. Mr. Deputy Speaker, the Member of Parliament for Caroni Central, in his incarnation as the Minister of Planning, did a fantastic job in terms of planning in this country. Let us not take away credit from the Minister of Planning. The Minister of Planning laid certain foundations in terms of serious institutional change and institutional development and redevelopment that had not taken place for years in this country. Right? And they're just trying to ignore it. But today, we are seeing them building on the very foundations that was laid by the Minister for Planning, whether that includes the Central Statistical Office and the direction in which it is going and what have you. But he laid foundations, and I am not going to allow anyone to take away from the credit from what was done by him and the People's Partnership Government. Even the worthy Attorney General and member for San Fernando West admitted today that this particular bill and the Planning and Facilitation of Development Bill was given impetus by the member for Caroni Central as Minister of Planning. And in terms of Maruga Tableland, harping upon we saying we had a plan. Yes, Mr. Deputy Speaker, we had a plan. And yes, Mr. Deputy Speaker, we have a plan for the future regeneration, reconstruction, and prosperity of Trinidad and Tobago. That plan was presented here in the budget debate. It was presented here. We had a plan, Mr. Deputy Speaker. In answer to my friend, we had a plan that created 50,000 jobs while we were in office. We didn't have a plan that caused us to lose 50,000 jobs under the current PNM. We had a plan that was bringing in foreign investments every year into the country. What is the plan now where you have a dearth of foreign investments into the country and you have no impetus being given to the kind of development that is required to diversify away from energy as a whole? We had a plan that was aimed at increasing tourism and the revenue from tourism. It was not just pie in the sky to say we are going to build the National Cycling Center or the Tennis Center or the Aquatic Center or what have you. Those were part and parcel of a wider cultural and tourism diversification plan. And the Oncology Center also. And I was coming to that because my next point was medical tourism. The whole idea behind the Children's Hospital in Cuba was not just about Trinidad and Tobago. It was about putting ourselves and our footprint in terms of medical expertise and the future for medical tourism in Trinidad and Tobago. Therefore, the foundations were being laid. We had a plan, and we have a plan for the future. Mr. Deputy Speaker, today we are hearing about 11 trillion cubic feet of gas being found, which has perhaps just doubled our gas reserves, quantum of gas reserves, and is now going to ensure that we have revenues, a stream of revenues for the future. Where did that come from? That came from the People's Partnership when Kevin Ratnarine was the Minister of Energy.
Mr. Deputy Speaker, regrettably, Standing Order 48-1, please.
Yeah, member, I want you to tighten to the relevance of the...
Speaker,
I want you to tighten to the relevance, so I'll give you a couple...
The member for Maruga Tableland said we didn't have a plan. If we didn't have a plan to resuscitate energy, today BPTT, Shell, and BHP would not be finding...
Mr. Deputy Speaker, regrettably again, Standing Order 48-1.
Member for Tabakit, I'd just like you to time the point that you are making. Yes, it's all about a plan, but what you are saying, I would like you to tighten with regards to the bill.
Mr. Deputy Speaker, it is about planning for the future. Planning for the future. And part of the planning was how we use not just our finite land, but how we use our sea reserves also in order to get things done, Mr. Deputy Speaker. Mr. Deputy Speaker, what our plan had in mind and how our plan was going to be used and how urban planners are going to be coming into this is that we were ring-fencing certain sectors in the country. Health was one.
I rise respectfully on 48-1. this bill to treat with regulation and establishment of urban planners. Mr. Deputy Speaker, I most respectfully ask you to confine this debate lest we open it too widely.
Now again, honorable members, as I mentioned, I'm giving Tabakit. He's going on to another point. I just wanted to tie it in quickly, and each member will have the opportunity accordingly when they are given the opportunity. Proceed, Tabakit.
Mr. Deputy Speaker, one of the things we were doing in the country is we were making our children from primary schools right up, technologically and IT sufficient and with a sufficiency, so that when they became urban planners and they had that profession in mind, they'll be able to compete globally.
You wouldn't understand that.
Mr. Speaker, Mr. Deputy Speaker, the member from Maruga Tableland spoke about consultation, and it sounded like he was frowning upon the whole idea of consultation. Consult. We are also always asking about consultation. Mr. Deputy Speaker, you don't build an inclusive society by arrogance and ignoring the feelings and views of others. You don't do that. You don't do that, Mr. And I'm responding directly to his matter of consultation. You build an inclusive society, you build a true democracy by respecting diversity, Madam Speaker. And then he talks about the inherited chaos. Everything was chaos. Well, go down to the passport office and find out how long it takes you to get a passport today. Go and see why people are lining up in the early hours of the morning for a birth certificate. Where is that chaos now from? How come people are getting a passport in a week during our time and a birth certificate in a day? How come a business was being set up in 3 days compared to 72 days under the period? Where is the chaos?
Or a bed in the hospital.
You see, so that, Mr. Speaker, I don't need to go more on that. I don't need to go more on that. Mr. Deputy Speaker, then he talked about, the member for Maruga Tableland talked about colonialism. You know, one of the things that this society has to understand, and understand very quickly, is either you stay mentally in colonialism or you make an instantaneous leap into independence. How long we are going to go on blaming colonialism for our present condition? How long are we going to do? That's why we're going to stay where we are. When you have a government that has a minister in Maruga Tableland getting up here and talking about blaming colonialism, it shows the psyche that now envelops that government. And therefore they're stuck in time. They're stuck in time. They're not futuristic. They're not visionary. And that is why the country is receding rather than progressing. We must understand that 1962 meant that we took responsibility for ourselves. And the quicker we stop blaming history for our present circumstance, it will really free our minds and free us, free our intellects to be creative and flourish into prosperity. Mr. Deputy Speaker, I just want to say, in response to my friend from Maruga Tableland, he talked about the number of people who are breaking the laws and squatting and doing what they are doing and so on. I agree. People are doing that. But you must ask the question also, you know, are the authorities and people who have been put in charge of institutions that should be given the permission and freeing up bureaucracy, are they the ones frustrating the process of development that causing people to take action that they shouldn't? And if it is that we have a situation as we have, then I would support this belief urban planners are going to cause us to bring some relief to that area of human beings, that quantum of human beings in our country who might find themselves in such an unfortunate position. What we should be doing in this country is finding a solution to the squatting problem that they talk about by trying to develop those communities and then really and truly enforcing the law thereafter. Mr. Deputy Speaker, I just want to remind that the United National Congress has always been and will always be about a homeowning democracy and a landowning democracy. My friend from Maruga Tableland talked about unregulated development and single out Central Trinidad.
Silence at the lower end of the chamber.
As if there is no unregulated development in other parts of Trinidad. You know, I want to ask something. What about the unregulated developments on the foothills of the Northern Range? What about all that unregulated development? What about the unregulated development destroying the forests and making the land bare on the northern range? And he talks about that we should be grateful in central Trinidad. Where is that water when it cannot get into the ground in those areas? Where is it going? Where is it going? Flooding Port of Spain, or it's coming down and also flooding central Trinidad? I want to remind the honorable member from Moroga Turbiland that it was the Minister of Planning, Dr. Tewarie, when those problems started, that he created regulation to say that people could not build above 600 feet, 300 feet on the range. Wasn't that good planning? Wasn't that good planning? Wasn't that good foresight? He talks about regulations. It was Dr. Tewarie, because the member from Moroga Turbiland said just now we'll have to build high-rise buildings because of the finite nature of the land. I agree with him. But that government was denying people that all the time. And that town and country planning was doing that, especially in terms of the committee that had to deal with appeals, which committee today is again frustrating people in this country from developing this country and creating jobs in this country and providing affordable housing in this country. Madam Speaker, is Dr. Tewarie, Mr. Deputy Speaker, Dr. Tewarie, the Minister of Planning, who came to Cabinet and spoke in Cabinet about increasing the heights of buildings in central Trinidad and other parts of Trinidad. Because we recognize that planning involves not just planning and developing Port of Spain, but developing the rural townships and so on, so we can have people living all across the country rather than flooding into Port of Spain to have to do everything. We were truly about planning in terms of devolution and diversification. Mr. Deputy Speaker. Mr. Deputy Speaker, today we are here to deal with this bill. And one of the things that was raised here this evening was the whole matter of the 3/5 majority. And the Attorney General saying that we do not need a 3/5 majority with respect to this bill. Madam Speaker, Mr. Deputy Speaker, this gives me an opportunity to go into the Constitution of Trinidad and Tobago. And I think it's important. And to put it on record for the public knowledge and public good.
Let the Privy Council tell them.
Section 4 of the Constitution, Chapter 1, Section 4. The recognition and protection of fundamental human rights and freedoms. Because I too, like my colleague from Caroni Central, believe that rights of people are being taken away or restricted by this bill. And I cannot be part of a parliament that restricts the rights of people when you're talking about a future society of freedoms and a greater freedom of the intellect also of people. It is hereby recognized, the rights enshrined, that in Trinidad and Tobago they have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental human rights and freedoms, namely, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. B, the right of the individual to equality before the law and protection of the law. C, the right of the individual to respect for his private and family life. D, the right of the individual to equality of treatment from any public authority in the exercise of any functions. Equality of treatment. E, the right to join political parties and express political views. F, the right of a parent or guardian to provide a school of his own choice for the education of his child or ward. G, freedom of movement. H, freedom of conscience and religious belief and observance. I, freedom of thought and expression. J, freedom of association and assembly. And K, freedom of the press. I will not go into section 5, but section 5 also is very important. But I simply read this into my presentation in order to enforce and reinforce the fact that you just don't willy-nilly come about and say that you are going to remove this requirement and put a requirement for a simple majority.
You sound like the Privy Council.
You know, I admire the Attorney General in terms of his very vociferous presentations here and his confidence he expresses in terms of his ability to want to convince. But you know, the Attorney General has been treading a path that I fear has certain dangers for the country, which is his somehow conscious or unconscious desire to remove these 3/5 majorities from legislation. Something which came by very hard fight to get into that constitution when the constitution was determined. And maybe one day, after the Attorney General has retired from the Attorney General in a couple of months' time, maybe a year time, he will probably tell us, you know, why is it that he wants these 3/5 majorities removed. But I think it's important, Dr. Tewarie, that we put it on record. What are these Section 4 and Section 5? Yeah, they're the constitutional rights.
And self-promoted.
Mr. Deputy Speaker, you know, in terms of this entire bill, you know, so much of this bill is about discipline and rules and so on of the council. But you know, I don't know, maybe I'm different, maybe I'm a simpleton, maybe I'm simple-minded. But I wonder whether we need all this kind of legislation or whether bills and legislation and our discussion here shouldn't be meant for one thing and one thing only: how to make life easier for people, how to foster development, how to reduce bureaucracy, how to kill frustration of people in this country, how to remove the stress of people. You know, when you read what an urban planner does, you will see the extent to which an urban planner is important. He's a professional who works in the field of urban planning for the purpose of optimizing the effectiveness of a community's land and infrastructure. They formulate plans for the development and management of urban and suburban areas, typically analyzing land use compatibility as well as economic, environmental, and social trends. In developing any plan for a community, whether commercial, residential, agricultural, natural, or recreation, urban planners must consider a wide array of issues, including sustainability, existing and potential pollution, transport, including potential congestion, crime, land values, economic development, social equity, zoning codes, and other legislation. And it's true. Dr. Tewarie, when this legislation was developed, I remember, you know, he always talks about the future and the 21st century. And the importance of the urban planner is increasing in the 21st century, because modern society is beginning to face issues of increased population growth, climate change, and unsustainable development. And an urban planner could be considered a green-collar professional, And urban planners will work in many different planning cultures, and therefore they will have to adapt. But one of the things, you know, I didn't see in the bill yet, but I saw it in the last clause of the bill, is exactly saying in the bill, or for the minister to say what an urban planner is expected to do. And in section 60 of the bill, clause 60 of the bill, it says here, 62D, without limiting the generality of the foregoing, the minister may make regulations for identifying the types of activities that could be undertaken by an urban and regional planner. And I consider that important, AG, because I think the country would like to understand really what will be the scope of work that an urban and regional planner can undertake. So unless we see the regulations, we will not be able to know exactly what the scope of this work will in fact be. So, Mr. Deputy Speaker, this bill is a very important bill. There's no question in my mind about the importance of the bill. It's an extremely important bill because in reality, professional standards are extremely important, especially in developing nations, where a lack of standards can and does result in classic situations, sometimes very difficult to reverse. And especially dealing with the use of one of the world's scarcest assets, which is land. It is important that the right balance be struck between environmental sustainability and human habitation and the use of land. And that is where I see the role of the urban planners. And that's why I said that I would like to see the regulations in terms of exactly what an urban planner is going to do. You know, I agree. in this case with the member for Maruga Tableland in this respect, that we have suffered enough from poor or no planning with respect to land utilization. But I also believe that we need to have a review of how decisions are being made with respect to, at the level of the authorities, with respect to change of use of land in Trinidad, with respect to high-rise buildings. You know, I implore the Minister of Planning and the Attorney General to read some very, very good articles that are being written by Ryan Damani in the Newsday, an urban planner, and where he makes a strong case for the way we look at Port of Spain and what is the current cost of an apartment in Port of Spain because of the restrictions that are being placed in Port of Spain. If Port of Spain is a dying city, as it is a dying city because people don't want to live here because it's too expensive to live, it's too congested to live, then you've got to make it in a way that is more attractive to people. People cannot pay $2 million for an apartment in Port of Spain, but if you look at what Mr. Damani is saying, and if you look at his vision and his construct in terms of his projection of ideas, you will see that maybe more people can be attracted to come back into the environs of Port of Spain. And similarly, we have to look at other places, like Chaguanas and so on. You know, as I speak about that, Mr. Attorney General, you know, one of the things that bother me about planning and the role of people in the current, what you call, state planning agencies, is the way they grant permits for people to set up funeral homes in residential areas or crematoriums. I really, really have a problem with that. Why are the state agencies allowing people to set up funeral homes all over the place, especially in residential areas?
Could they expect to kill
and affecting the cost of properties. This is a very serious thing.
No other comments, please.
A very, very serious thing. And it's a matter that I'm raising here, not because, you know, I have anything against anybody doing business, but we have to have some regulation of what? You know, the only funeral home in this country that does not establish in a residential area is Das Funeral. They have established in an industrial area in Chaguanas, an industrial area in San Fernando. They're the only two that I know. Batu, okay. But you have everybody else just setting up crematoriums on Coffee Street and all about, and the state agencies are allowing that? It's nonsense. So I hope, you know, those are kinds of issues urban planners are going to deal with in the country. Mr. Deputy Speaker, people with cash in this country do not see the need to make applications and go through the tedious process. They just don't make the application, they don't go through the tedious process. They build. They just build. And they bank on a certain theory, which maybe the Attorney General could tell me if this is right or wrong, if I'm right or wrong. They bank on a theory, a widespread theory and belief, that they cannot be affected if after 4 years the authorities have not done anything to break down their building or to affect them. And that is something, you know, that we have. Now, while the creation of this council would create a code of ethics to supposedly regulate the behavior of planners, it will not deal with the rampant problems of unplanned and authorized developments, which have been known to contribute to the myriad of flood-related problems. So policing the profession is important. It will encourage a greater level of professionalism, but in a sense, that's all it does, until you really are serious about the insurance and indemnity and so on that you're asking people to have, and that you could carry them to court for giving poor advice or what have you. Well, you know, I want to ask certain questions. What about all those people who have been given poor advice to the HDC, that we see some of those houses falling down and they don't have steel in the steps? What about the people who gave advice to building up all those houses in Greenvale? Yeah. Who are the consultants? Who are the architects? What about Las Alturas and so on? You know, who are the ones who gave all that advice? You know, do those people and those professions come under an act in which they have to have indemnity insurance also? So if you're putting this here, are you going to, and you don't have indemnity insurance now for all those other categories, are you going to revise the legislation also for those other professions, that they will also have to have indemnity insurance?
You're bright, boy. You're bright, too.
Mr. Deputy Speaker, because you see, the 6th schedule of the ethics, the code of ethics in this makes some very important points. And I want to refer to the 6th schedule, where it says here in paragraphs 3 and 4, an urban and regional planner should consider in his practice of urban and regional planning the following concepts: that land is a finite resource, particularly in small island states, and should be utilized in a judicious manner. Mr. Deputy Speaker, in this parliament, we recognize in a budget debate the importance of land. The Honorable Prime Minister sat in that seat, and when he spoke, he talked about the Tabakit Initiative. And part of the Tabakit Initiative was, in that budget, saying to the government, allow people to develop 4 apartments on a 5,000 square feet of land. You know, today, Mr. Deputy Speaker, up to this day, people are being denied the opportunity to buy a cheaper apartment because the Minister of Planning has not changed the regulation and she refuses to do it. 4 years later.
Antediluvian.
Anti-people, anti-poor people, anti-middle class, anti-lower middle class. This is a serious thing. So you're asking the urban planners that land is a finite resource and so on. But they will make all the recommendations. But are they going to be frustrated by the system? And are they going to be frustrated by the bureaucrats? Because, Mr. AG, you did refer to that they are going to be working in a framework. But is the government prepared to revise that framework and to revise that archaic set of rules and regulations that is now frustrating developers in the country? Mr. Deputy Speaker, the need to protect the integrity of the natural environment is what urban and regional planners should consider. He should consider problem solving involves an analysis of choices which requires the balancing of competing interests. He should consider the need for meaningful and informed public participation in the urban and regional planning process and due consideration of available choices. But yet I hear the member from Maruga Tableland talking about too much consultation. And yet you're asking the urban planner in the Code of Ethics to make sure that they respect all of that. And then the urban planner should consider the following concept. And listen to it: the rights and privileges of individuals under the Constitution and other written laws. And here we are talking today about removing the 3/5 majority. The pursuit of excellence in design, whether in natural or built environment. The need for public advocacy and the desirability of monitoring and evaluating the implementation of a plan. So, you know, you're asking the urban planner to do all of this. I agree, Mr. Attorney General. These are good things. These are very good things. Nice framework within which Code of Ethics they are going to work. But the question for me is, you want them to do all these nice things, but what is being done to change the environment in which they are going to operate? Change those archaic rules and regulations. Not when we come to this parliament and discuss something and agree upon it, and then the minister refuses to change the regulations. You know, I'm in and out of town country planning every week, you know. And last week somebody in town country planning said to me, yes, yes, of course. I go and sit in the public gallery, they will tell you. And I wait until my number is called. I wait until my number is called. And then I go in. Somebody told me, be afraid you go and talk in Parliament again about us. You know? Madam Speaker, Mr. Deputy Speaker.
Honourable Member. Your initial speaking time has elapsed. You have an additional 15 minutes. You care to avail yourself?
You need plenty more than that.
Member.
Yes, I'm taking it, Mr. Yes.
Well, you didn't
Yes,
say.
yes, yes. I said
Proceed,
yes.
proceed.
I nodded, yes.
Proceed.
Now, so the whole question of the registration of planners and so on, it causes me concern. You see, my colleague, the member for Caroni Central, you know, talked about restrictiveness and whether this bill will cause people to not to enter the register, or whether, you know, things will happen that people are denied being registered. But you see, there's an issue here. you have a situation where, and I'm subject to correction, but I think my colleague, Dr. Fuad Khan, could correct me. There was a time when people used to complain that they couldn't get registered as a pharmacist because there used to be a cartel controlling it. I don't know what is happening now. I remember having to go as the mayor of Chaguanas and beg to see if I could get somebody into the pharmacy program. What about the nurses in this country who are complaining to me now in my constituency they're having difficulty getting registered? Huh? And no jobs. No jobs for pharmacists, for pharmacy graduates. It's an article, 22nd of May 2009.
Speaker, standing order 48-1, please.
Again, member, I'll give you a couple seconds to tighten in order to the relevance of the particular bill we are debating.
I'm dealing with the question of restrictiveness, and restricting people from entering the profession.
And in terms of the relevance with the bill?
With the bill, because you talk about what are the conditions under which people are going to be registered and as a professional and what have you. It's here in the bill. The bill is flooded with pages of that. What kind of qualifications they have to have, the kinds of recommendations they have to have from people. Suppose they can't get those recommendations. Suppose there's a cartel of people dealing with this thing, right? A cabal. Then what happens? Then what happens to people?
They are bright.
So it is of concern to me. Mr. Deputy Speaker, for someone who wants to develop a plot of land, right? And I hope our understanding, Dr. Tewarie, is correct, that urban planners would not be required below 20. But the way this government acts, you might end up with an urban planner having to sign your plan, you know.
They're not supposed to be required.
But right. So let's hope that what is there in the facilitation of development bill really ties in with what is in this. And that not every person, Mr. Deputy Speaker, wanting a plan will then have to go and get it signed by an urban planner. That we'll have a clear ideas of what the urban planners will sign and what they wouldn't sign. That is not declared yet in the legislation. That might be part of the regulation, but I don't see it in the legislation. So while the bill lays out the criteria, there are many persons who are, by reason of their occupation in both the private and public sectors, they are deemed urban planners. Now, for someone who wants to develop a plot of land, generally, such a person now does not necessarily have to go to a town planner or even an architect, but perhaps a surveyor and a draftsman, or someone who can develop a subdivision plan, and they submit it to Town and Country, and at Town and Country they will apply possibly land use zoning criteria and other regulations, and such a plan will be passed or not passed. The question is, would such a developer, any number of lots of land, any number of houses, now have to use a registered urban planner to prepare documents when this bill is passed? I want us to be very clear on this. Will this incur then additional development costs? And would it make a difference if all the town planner is doing is duplicating the existing work of the surveyor according to the Town and Country planning regulations? Because right now the surveyor or the draftsman or even the individual, all they do is meet the requirements of the Town and Country regulations. And if it is that all the urban planner is going to do now is meet those regulations, then whether you like it or the urban planner is going to work within the regulations. Mm-hmm. So if those regulations continue to be restrictive, if those regulations continue to be regulations that are not in keeping with modern day requirements for human habitation and development and what have you, Mr. Deputy Speaker, we are not going to go anywhere. We are not going to get anywhere. All we are doing is creating this particular profession under the Act, but we are not going to progress. Mr. Deputy Speaker, now, I know the word urban and regional planner, and I wondered whether the word regional planner should not have be included there, rural also. You know, if this country is to progress, and if rural underdevelopment is to be attacked at its core, then rural planning is also important. And I find, you know, when you talk about urban planning, there's a kind of bias in the language. Also, although maybe they try to capture it with regional planning, but I would like to hear that we're talking about rural planning and rural development also. Because you see, part of our problem in terms of urban planning or planning has been the focus upon urban communities and townships. And despite the preoccupation of regional plans by the Ministry of Local Government, we have not seen this really manifested, you know. Look, each corporation, since the days of Mrs. Hazel Manning, were asked to do regional plans, you know. But what has happened to these regional plans, or spatial plans, as they call it? What has happened to them? Nothing really has happened to them, you know. Because everyone sees that as an exercise in futility because of the overpowering regulations of the town and country and what have you. And then there's another reason. Because it has to be tied to development, an overall development plan. And the government of the day must take notice of what they're asking local government to do and not ignore it by their overwhelming advocacy of their own position to the exclusion of what the people want.
Big strategic.
Because I can tell you, those strategic plans, spatial development plans, were developed after wide consultation in the regions, you know, wide consultations. Yeah. So, Mr. Deputy Speaker, I hope that changes in the environment, social and habitational changes that are taking place without a change in the town and country behavior, attitudes, and regulations would not cause these urban planners, professionals, to be working in a stagnated environment. Now, Mr. Deputy Speaker, a question I'm sure that has arisen in people's minds is, why do you need legislation at all to regulate the work and professionalism of urban regional planners? And as I said, it could be answered in asking, what threats do people, communities, or society face if the work of urban planners are not regulated? A lot of the answer to this question will come from an understanding of what urban planners do. And I come back to that point, Mr. AG. I come back to that point. You know, let's clarify what are they expected to do in the country. Because this bill is highly regulatory, you know. If you really read this bill, it's highly regulatory. And for it to be effective, so much of the bill is focused on disciplinary matters. I think it will be necessary to understand the policies of government or ministries which urban planners are supposed to adhere to and follow in their work outputs. So, as I close, let me just reiterate some of the issues I raised. Is it now necessary for all plans being submitted to Town and Country for approvals to be signed by a registered town planner? Does this include not only land development plans, but also simple residential housing plans and under 20 lots? What is the future of technical people at the Town and Country Planning Division in the approval process? How are state planners going to be incorporated into this bill? I think the bill allows for state planners to be incorporated. But do they have to become members of the Society of Planners first?
Yes, they do.
Right. If the plans must be vetted and signed by a registered licensed urban planner, how would the fees be determined? Would the fees be regulated, and if so, by whom? Because the clause does make, the bill makes reference to people could go to court, get back money, and so on and so forth. Now, you know, if you go to a surveyor now, not surveyor, valuator, you pay 1/4% of the value of the property, right? So on a $2 million property, you're paying about $5,000 for the valuation. So how is this going to be, how are urban planners going to be remunerated? Is it going to be a private arrangement between the client and the urban planner, or is there going to be some kind of regulation by the minister in terms of fees? Okay? The other question is, you know, how do you prevent abuse by the council if they attempt to limit the number of licensed urban planners? Right? How do you do it? What is the entitlement of the Society of Planners members to be actually placed on the list, on the register, and issued a professional license? And I say that because there are several categories of members on the list, on the TTSP list. Many categories. I see that only one category is being allowed, professional. how are the other categories going to be brought into the picture? Okay? So these were some of the matters I want to raise, except that with respect to appeals, the Environmental Commission is the court that has been named as where the appeals could be launched. But is this going to be a final court, the Environmental Commission, that is going to be determined there and there are no further appeals? What's going to happen? What's going to happen after that, AG? And, really, how competent is this court to deal with these kinds of matters? How competent is the court to deal with these kinds of matters? I think that's, I don't know. The member for Maruga Tableland said he was not a lawyer. I'm not a lawyer. Therefore, I am Lavendale West, permitted to ask that question as a layman on behalf of all lay people in the country. I see you are basking in your new appointment, but the people are not basking.
First time minister.
So, Mr. Deputy Speaker, having said all that, I want to go back to what this member for San Fernando West said about the failure of enforcement in this country. You can have all of this. But the best town plans developed by technically competent urban regional planners will have no use unless there is enforcement. No use. No use. People are changing water courses. There are boundary line violations. They are not putting in utility corridors. Roads and drainage specifications are not being looked at. There's so much abuse taking place. So much abuse taking place. So urban planners may have the best of intentions, but their vision, their expertise could be severely undermined by defaulting developers, Mr. Deputy Speaker. So, Mr. Deputy Speaker, I think it's a good idea to have urban planners. I think it's a good idea to have them as part of the profession. But I have raised some concerns which I hope that the Attorney General will deal with in his wind-up. Thank you very much.
Honourable members, at this time, we will suspend for tea, as agreed by the Leader of the House and the Chief Whip. We will resume at 5 p.m.